लाए हैं? आप ही लाए हैं?
Partially completed. Only 2 issues of damages and security deposit I could not complete. Otherwise,
May I have only 2 minutes time to say one line? So far as refund of 50,000 is concerned, in view of 12A of Exhibit 2, it was automatic termination without notice.
Exhibit
2. Clause 12A, which says it will be cancelled if within stipulated time they will not deposit the sale value. Sale value is defined in clause 10, entire sale value. It says that if it is not deposited within specified time, time is also prescribed in clause 10, that it says within 10 working days from opening tender. If not deposited, then sale will be cancelled, the security deposit will be forfeited and materials will be resold without any notice. So my only submission is all 3 acts without their notice is performed and they accepted for 23 years, 1992 to 2050. This 23 years, and therefore in view of section 62 of Indian Contract Act, it says that the contract can be terminated by 3 means. First, novation, second, alteration, and third, rescission. It is not a case of novation. Novation means entire contract, their contract scrapped, there was new understanding. That is not their case, novation. Second, alteration means the earlier contract existed but certain terms modified and by conduct it can be sued, it is modified. That is also not their case. Third is rescission. Now my submission is that the Act does not require that rescission must be in writing when the contract says that it is without notice. Therefore, the case would be that it's an implied rescission of contract which has either happened in 1982 when their witness says that their material I sold to someone else, or at best till the judgment of 1992 when the court has given their option. Why the court has given that option? Because the contract was of 1980, the money suit was filed within 3 years, 1983, money suit of 45, 1983. So since they have approached the court, therefore court has said that the contract is subsisting because the relevant date would be approaching court, not the pronouncement of judgment. Therefore the trial court has said that since they have approached the court, that is our submission, therefore contract is subsisting but they cannot grant this relief they want, they can represent and file a suit. That they have not done 23 years for some reason which I say is not it.
may I just clarify clause 10 which my learned friend is relying on. Clause 10 says
clause 12.
Clause 10 first because he says payment has to be made in entirety. That payment is not in entirety, it's payment in full towards the value of the installment of supply. What had happened, 250 metric ton was the installment of supply at that time. We paid for the entire 250 metric ton. They did not supply. We filed the suit in 1982. They, despite filing the suit, took stand. They never took the stand that you have not paid for the entire 795 metric ton. So we filed the suit in 82 saying that whatever installments were given to us of 250 metric ton, we have already paid. If the suit in 1982 we did not make the payment of the entire 795 metric ton, they could have said that the contract was terminated then, despite not having the entire payment.
After the judgment in the money suit, did you make any payment?
The occasion for payment would arise only once they say that they are ready for the delivery. Because the deliveries were to be made in installments. That is what clause 10 says. Delivery to be made in installments, then payment have to be made in full. So that payment in terms have to be made in full is towards the installment of deliveries, not of the installments which have not been communicated to us.
Apart from that letter, exhibit 10, exhibit 2, I don't know.
Exhibit 10.
Exhibit 10, 93 letter.
90.
Do you have anything else?
Exhibit 7.
Exhibit 7.
7.
Exhibit 7 is 93 letter.
No, Exhibit 7 is the letter after the disposal of the other criminal case, which we
Yeah,
said,
that is 2015.
wherein we asked them.
No, from 2015 is proved. Exhibit 10. Apart from Exhibit 10, do you have any other document?
I have the judgment which records their written statement, which record what was their stand. That's it.
And your witness has not stated anything about Exhibit 10.
He has just formally kind of exhibited it in the subsequent examination.
That's it.
That's it.
Just only nothing more has been stated as to
does
what
not
he did,
content,
what happened.
He has not said.
We are simply exhibited it.
Only exhibited. He has not said. But at the same time, they never. There is not even a single communication by SAIL terminating the contract. Not even a single instance where SAIL offered us to refund the 50,000 security deposit. So they retained the security deposit all this while, showing us that the contract is still valid.
My case is that it is not retention, it's a forfeiture in terms of wealth, and that too without your notice.
अब बैठ जाइए धीरे धीरे लिखाते हैं. It will take time. ना? आप लोग को कहीं कहीं जाना है तो जा सकते हैं, सुनना है तो सुनिए.
One second judgment, sorry. One judgment is the moment court comes to a conclusion, it's a time bar claim, no further adjudication can be done. Paragraph, I would say paragraph 17, 18, 22, 23. The fact of this case is that the trial court has dismissed the suit on the ground that it's a time bar claim. The appellate court has reversed it on various aspects. The Honorable Supreme Court has remitted it back to decide first question of limitation, because once limitation is
17 to
17, 18, 19, 22, 23. The Honorable Supreme Court says in terms of section 3(1), the moment it is decided, it is time barred, though it is harsh, but court seizes jurisdiction.
आप लोग से बस एक ही रिक्वेस्ट है, जितना देर हम आपका सबमिशन लिखाएंगे,
I am here.
उतना देर आपको
Yes, I am here.
ये बाकी तो you need.
Once I got scolded, I will make my way. Once I got scolded, now my tail is straight. Nothing. I will stay.
आपको भी कहीं और काम है? आप
But
जाइए.
I'll
It will take time. आप जाना है, आपको जाइए. कोई दिक्कत
I will assess matters. On facts he can trust, I will not make the wrong submission.
The moment my matter is about to reach out, take leave.
लीव लेने की जरूरत नहीं, आप ऐसे ही चले जाइए, क्योंकि उससे डिस्टर्बेंस ही होता है. Ask your junior to be there. Aditya, you are there with him? You are there with him? तो वहाँ जाके देखिए ना, वहाँ कौन है, वहाँ किसी को रखें? I knew he is there with you. तो हमको लग रहा था कि First appeal number 271 of 2023. Heard the learned counsels appearing on behalf of the parties. This appeal has been filed against judgment and decree dated 25/7/2023, within bracket decree signed on 4/8/2023, passed by the Civil Judge Senior Division Roman 2 at Bokaro in original suit number 48 of 2016, whereby the suit for specific performance of contract and slash or for compensation slash damages and also for refund of security deposit has been dismissed. The trial court has framed two issues. Issue number one, whether the suit is maintainable in its present form, and issue number two, whether the suit is barred by law of limitation. The learned trial court held that the suit was barred by limitation and also held that the suit was not maintainable in the present form. The records of the case reveal that there were two defendants. You represent both the defendants?
Yes. Legal country.
There were two defendants, and the court had issued summons to the defendants by registered post, but both the defendants did not file their written statement, and by order dated 22/6/2018, both the defendants were debarred from filing their written statement. It further reveals from the record that although the written statement was not filed, but they had participated in the proceedings and had duly cross-examined the witnesses. The suit was filed for the following relief. Plaintiff say prayer to. The aforesaid prayer F and G seeking damages / compensation. They are seeking damages for an amount, seeking damages and refund of security deposit as contained in prayer F and G were introduced by amendment dated 30/8/2022. The defendants were, you filed your additional written statement?
No.
The
opportunity was there.
opportunity must have been there.
Opportunity was
No additional written statement was filed by the defendants. However, after allowing the amendment, the plaintiff witnesses were examined again in support of the amended plaint and the amended prayer made therein. The suit was filed for delivery of 495.450 metric ton of used and old conveyor belts.
Was filed for 714 points.
Where में पैरा नंबर में थे
Para?
ये जो सूट का प्लेन है फर्स्ट पेज for delivery of 495.450. and was valued at rupees 33 lakhs. At the time of filing on 27/5/2016. However, at the time of amendment, since the claim for damages and refund of security deposit was also introduced, the suit valuation was revised to rupees
1,60 lakhs 46,007.
1 crore 60 lakhs 45,000 7. ये जेम्स बॉन्ड टाइप का नंबर हो गया. 1 crore 60 lakhs 45,007. And deficit court fees was also paid for the same. The records further reveal that a petition was also filed by the plaintiff stating that the suit was required to be transferred to commercial court in view of the revised suit valuation, but the same was simply kept on record and no order was passed on the same. And ultimately the suit proceeded and it was decided on merits. However, the appellant has raised the plea that the court lost its jurisdiction to decide the suit, and consequently the impugned judgment on this ground alone cannot be sustained. The learned counsel for the appellant, by assailing the impugned judgment and decree, has submitted that there being no written statement filed on behalf of the defendants, the facts mentioned in the plaint remained uncontroverted. He has also submitted that the evidence were also produced in support of the case of the plaintiff. The learned counsel has submitted that a tender notice was floated by the defendants way back in the year 1979-80 for inter alia for sale of used and old conveyor belts on as is various basis, in which the plaintiff participated and had given his quotation in which the plaintiff participated against serial number 33 of the material list, being inverted comma used an old conveyor belt of assorted size inverted comma close, quantity 714.80 metric ton, along with requisite earnest money of rupees 30,000, and thereafter upon negotiation a letter dated 20/2/1980 was issued by the then controller of stores of the defendant company, communicating to the plaintiff that the offer of the plaintiff for purchase of 714.800 metric ton of used and old conveyor belt of assorted size on as is various basis at the rate of rupees 6650 per metric ton plus sales tax as applicable, subject to terms and conditions of the tender, was accepted. It is the further case of the learned counsel has further submitted that the defendant instructed the plaintiff to lift 50 metric ton of used and old conveyor belts in the first installment after making necessary payment, and thereafter in 9 installments. Consequently, the amount of rupees 30,000 deposited on 26/6/1979 and further rupees 20,000 deposited on 28/1/1980 as earnest was subsequently converted as security deposit amounting to rupees 50,000 against the contract. It was for the case of the plaintiff. The learned counsel has also submitted that the plaintiff had deposited a sum of rupees 16,62,500 by way of advance payment towards first and second installment of 50,000 metric ton each, and third and fourth installment of 75 metric ton each towards lifting of material and the plaintiff was supplied only 219.350 metric ton out of 250 metric ton for which the money was deposited, and consequently a balance amount of rupees 2,03,822.50 was lying deposited with the defendant. Thus, the remaining amount to be deposited to remaining material to be supplied was 495.450 metric ton. Further, the last payment was made by the plaintiff on 30/7/1980 and last delivery was made to the plaintiff on 6/8/1980. It was further case of the plaintiff that while the fourth installment of material delivery was going on, a criminal case was instituted, being Marafari PS case number 12 within bracket 880 on 6/8/1980 against several persons, and another case being Marafari PS case number 15 within bracket 11 bracket close 80 was instituted against some of the officers of Bokaro Steel Plant. Who were alleging malpractices in awarding the aforesaid contract to the plaintiff. It was their case that pending investigation of both the criminal cases, the balance quantity was not supplied on the ground that the delivery will be given to the plaintiff after disposal of the criminal case. It was their case that the defendant started delivering old and used conveyor belts to other parties, which was brought to the notice of the defendant by the plaintiff by letter dated 5/6/82. However, subsequently, in one of the criminal cases being Marfari PS case number 12 within bracket 8 bracket close 80, final form was submitted indicating mistake of fact, and the case was closed on 14/9/1982. In such circumstances, the plaintiff served a legal notice dated 16/7/83 either to give the balance contracted material or to refund a sum of rupees, the balance amount of rupees 2,03,822.50 which was lying with the defendant, and also for refund of security deposit of rupees 50,000 along with interest. Having no response, ultimately money suit number 45 of 83 was filed against the defendants for the relief which has been quoted in paragraph 20 of the plaint, which was primarily for a refund of rupees 2,03,822.50 within bracket advance payment, and refund of security deposit of 50,000 with an alternative plea that the defendant be directed to supply the balance quantity of conveyor belt weighing 495.450 metric ton within a fixed time. The Learned Counsel has submitted that the suit was contested and was ultimately decided by वो आपका हिंदी ट्रांसलेट हिंदी वाला स्क्रिप्ट वाला है White judgment and decree dated 9/4/1992, whereby the defendant was directed to refund the advance amount of rupees 2,03,822.50 with interest at the rate of 12% till the date of payment. However, the court observed that the contract was still subsisting and therefore there was no question of refund of security money. The Learned Counsel has submitted that the court further observed that as far as question of getting relief about supply of balance conveyed belt is concerned, the plaintiff would bring a separate suit if on the request of the plaintiff the defendant fails to supply the materials mentioned in the contract. The Learned Counsel submits that by the time the suit was decided, only one of the criminal cases was closed, and the other criminal case, which was Marfari PS case number 12 within bracket Marfari PS case number 15 within bracket 11 bracket close 80 was still pending. He has also submitted that the defendants had taken a specific stand in their written statement filed in the money suit number 45 of 1983 that as long as the criminal case was pending, there was no question of any supply. The Learned Counsel has further submitted that it is also not in dispute that has further submitted that the plaintiff had also disclosed that after the judgment and order dated 9/4/1992, the learned sub-judge Roman 2 Bocaro in money suit number 45 of 83, the defendant refunded the amount of rupees 2,03,822.50 along with interest to the plaintiff. In the same year, while the security deposit of rupees 50,000 was retained by the defendant, and till date the same continues to be with the defendant. He has further submitted that as the other case, namely other criminal case, namely Marafari PS case number 15 within bracket 11 bracket close 80, ended in an acquittal of the petitioner of the plaintiff and other accused persons, while judgment dated 13/3/2015 passed by the Special Judge Vijay Sambar and a copy of the same was forwarded to the Chief Executive Officer of the defendant company, And further, the plaintiff by letter dated 18/9/2015 sent through registered post made a request to the Chief Executive Officer of the defendant company for resumption of the delivery/lifting a balance contracted quantity of 495.450 metric ton of used and old conveyor belt at the contract rate of 6,650.00 per metric ton plus applicable taxes, which was the rate fixed as per the contract way back in the year 1980. In terms of the judgment and order dated 9/4/1992 in the suit, the plaintiff also expressed his willingness and readiness to deposit the payment of the subsequent installments as soon as communication is received from the defendant. But the plaintiff did not receive any communication till the date of filing of the suit, and ultimately the suit was filed. The learned counsel for the appellant has also referred to the fact that a petition under Order 6/17 of CPC dated 1/8/2022 was filed before the court under section, by referring to section 21 within bracket 5 of the Specific Relief Act 1963, read with section 151 of the Code of Civil Procedure, by submitting that as per the provision of section 21 of the Act of 1963, it provides that at any stage of proceeding, the claim of compensation could be included, and thereafter the plaintiff was permitted to incorporate the amendments in the plaint, whereby paragraph 34A to 34D were added, and further relief in terms of prayer F and G were also added. The learned counsel has submitted that the plaintiff had filed numerous documents the learned counsel has submitted that as the amendment was allowed after the closure of evidence हो गया होगा ना?
Yes.
After the closure of evidence of the plaintiff, upon amendment, the plaintiff witnesses were again examined.
Prayer was rejected, allowed by the High Court.
Oh, allowed by the High Court.
Yes, the amendment was carried out on 38/2022. They have filed application for recall of witness on 7th November 2022, which was rejected. Then they
Okay,
moved.
just a moment. The amendment was allowed on 38/2022. They filed their petition for recall of witness on 7/11/2022, which was rejected
On the same date.
on the same date, against which they moved this High Court.
In CMP 958 of 2022.
In CMP number 958
of
of 2022, the CMP was allowed, and ultimately the witness was examined on recall.
Witness were recalled on 10/5/2020.
The witness was recalled on 10/5/2023
2023
and were
and re-examined on 22/5/2020.
re-examined on
22/5/2023.
22/5/2023.
Yes, got it.
The learned counsel has submitted that upon recall, Exhibit 10 was produced, which was original copy of letter/notice dated 10/2/1993, issued by the plaintiff to the defendant. (1993) a letter, Exhibit 10. He has specifically placed the said exhibit to submit that immediately after the judgment passed in Money Suit number 45 of 1983 dated 9/4/1992, the plaintiff had approached the defendant through the managing director that for taking delivery of the balance quantity of 495.350 metric ton of used and old conveyor belt, and also disclosed that the officials of the defendants were saying that the supply of the balance quantity of material cannot be effected while the criminal case bearing Marafari PS case number 15 within bracket 11 bracket close 80 was pending, and the delivery of the material will be made only after outcome of the case. It was also stated, the plaintiff was also told that were also advised by the officials of the defendants to wait till the disposal of the case for lifting of the balance material. He submits that by the said letter, the plaintiff expressed their readiness and willingness to deposit the material value of the installment as soon as communication is received from the end of the defendants as per the procedure and terms and conditions of the contract, and also indicated that plaintiff was waiting till the outcome of the criminal case, and the defendant company is stopped from taking any adverse action against the matter. The Learned Counsel has submitted that the said letter was sent by registered post. However, no registry receipt of the same was exhibited and no receiving of the said letter is on record. The Learned Counsel has submitted that in spite of aforesaid, in absence of any written statement on behalf of the defendants, the evidence brought on record by the plaintiff in support of the case remained undisputed and uncontroverted. Correct? And therefore, there is no legal impediment in taking into consideration the letter dated 10/2/1993.
In fact, it was marked also without objection.
He has submitted that this document was marked without objection from the side of the defendants who were participating in the trial. The Learned Counsel submits that the Exhibit 10 was sufficient to hold that the defendants were that the delivery could not be made to the plaintiff in spite of the judgment passed in Money Suit number 45 of 1983 dated 9/4/1992 merely on account of the pendency of the aforesaid criminal case being Marafari PS case number 15 (11) 80. The Learned Counsel submits that thereafter in the year 2015, when the said case ended into acquittal, the plaintiff served a notice. The plaintiff served a letter dated 18/9/2015 addressed to the Chief Executive Officer of the defendant company, giving the entire background, and requested for resumption of supplies. The Learned Counsel submits that at any point of time, the agreement was not terminated as the defendants were conscious of the fact that the supplies would resume once the criminal case ended. The Learned Counsel has submitted that as the contract was still subsisting, the plaintiff was entitled for supply of the balance quantity as per the terms and conditions of the contract, for which the rate per metric ton was fixed at rupees 6,650 per metric ton as back as on 20/2/1980. The Learned Counsel has submitted that physical running of time after the money suit will not be decisive in view of the fact that the entitlement of the plaintiff continued and was only suspended on account of pendency of the criminal case. And once the criminal case ended into acquittal, the right to receive goods in terms of the contract revived, and therefore the cause of action for the suit is to be counted from 18/9/2015, and the suit was filed soon thereafter. The Learned Counsel submits that the Learned Trial Court erred in law in holding that the suit itself was barred by limitation. And accordingly, the aforesaid fact regarding non-supply of the balance quantity of balance 450 point 495.450 metric ton, as well as the rate remaining undisputed, the plaintiff is entitled for a decree for supply of the said amount. He submits that if a decree is passed to that effect, then under such circumstances, there is no question of refund of compensation amount or baki, refund of security deposit or compensation.
Compensation will not be.
And
If it is.
and if this supply is allowed, there is no question of any compensation as well. He has submitted that the claim of compensation / refund of security is only as an alternative plea. The main relief is supply of the balance quantity of 495.450 metric ton at the contract rate of 6650 per metric ton, fixed as per the contract on 20/2/1980. आपका वो उसका तो हम लोग jurisdiction वाला तो आपका लिखा दिए थे ना, I think लिखाए थे ना, submissions लिखाए थे ना, वो हम इसमें incorporate कर देंगे. वो submissions are there, ठीक है, उसमें लिखिएगा. I think हम dictation दिए थे.
Limitation aspect, Article 54 is applicable, and it says that it will start when the plaintiff has noticed that performance is refused. So
The Learned Counsel has submitted that the period of contract as such was not fixed, and Article 54 of the Limitation Act would be applicable, and the period of limitation will commence 3 years from the date when the plaintiff is informed about refusal of performance of contract. He submits that in spite of notice having been given, in spite of request having been given in the year 2015, when no response was received, the suit was filed seeking relief of supply of the remaining material, and therefore even if no reply to the notice is taken as refusal to supply, then also as per Article 54 of the Limitation Act, the limitation would commence from the year 2015.
2015, having notice to refusal should be there. So they never noticed me that they are refusing from performance. So only when they did not reply to my letter to supply.
So at best that can be taken as a refusal.
So my contention is that only after that 2015 letter, there was a notice that they will not perform.
That's right. He has submitted that only after the issuance of letter in the year 2015 by the plaintiff, it came to light to the plaintiff that defendant are not willing to perform their part of the contract, which was the last cause of action for filing the suit. First and the last cause of action for filing the suit. For so far as the resumption of supplies are concerned for the balanced quantity. आपने कौन-कौन सा एविडेंस रिलाई किया है? ओरल एविडेंस?
Oral evidence is only one.
आपने
Documentary,
और कोई डॉक्यूमेंट्री एविडेंस रिलाई किया है?
मतलब एक
बाकी तो सब एडमिटेड है.
हाँ, मतलब Exhibit 8 भी है मतलब,
हाँ.
which is I could not trace, which is very important.
हाँ.
Exhibit 8 is the document मतलब whereby sale is asking payment towards installment of deliveries. They say that no, that was not the case. So from Exhibit 8, it is the document of sale whereby for whatever is available with them, they are asking the payment.
Okay. The learned counsel has also referred to Exhibit 8 to submit that as per Exhibit 8, the defendant used to demand the amount to be deposited by the plaintiff with respect to the material which was available for supply. He submits that the installment was already fixed. The supply was to be made in installments, and the payment was also required to be made in installments.
Installments after the communication of availability.
After the communication of availability of the material for
As-
supply,
As provided in Exhibit 8.
as provided in Exhibit A. Exhibit A बोलते हैं हम.
8.
As provided in Exhibit 8.
That's a letter by Steel Authority.
The learned counsel appearing on behalf of the respondents, on the other hand, has submitted that at the time of filing of the money suit number 43 of 1983, two criminal cases were already pending, and it was only in one criminal case final form was submitted, and at the time of judgment also the other criminal case was pending. He submits that in spite of pendency of one of the criminal cases, the learned court, while decreeing the suit, had directed the plaintiff to approach the defendants for the purposes of taking the balance quantity. The learned counsel has submitted that the marking of the letter dated 10/2/1993 as exhibit is without any objection does not amount to proof of the document, much less dispatch of the said letter. He has also submitted that the suit was filed through the power of attorney holder, who was through the power of attorney holder, but the proprietor of the plaintiff namely Prem Kumar, never deposed before the court. He has also submitted that in his evidence, the power of attorney has not disclosed the content of the letter dated 10 to 1993 and it has only been exhibited. And on account of non-examination of Prem Kumar, on behalf of the plaintiff, the original plaintiff, that is the proprietor of the plaintiff, could not be cross-examined with respect to the said document. The learned counsel has also submitted that in the plaint, there is no reference to the letter dated 10 to 1993 and there is no reference as to what the plaintiff had done during the intervening period from the date of disposal of the suit till 2015. The learned counsel has submitted that the letter dated 10 to 1993 was not placed on record when the plaintiff witness was initially examined. It was placed on record only after the amendment was allowed and the plaintiff witness was recalled, and apparently this document is an afterthought. He submits that in absence of any foundational pleading in connection with any action taken by the plaintiff after the disposal of the money suit till 2015, this document has no value in the eyes of him, apart from the fact that the said document has neither been duly proved, nor its dispatch has been proved, nor the proprietor of the plaintiff has adduced evidence so as to enable his cross-examination, nor the plaintiff witness has stated anything with regard to the contents of the letter dated 10 to 1993. The learned counsel has submitted that after the disposal of the money suit, the claim for balance quantity, the cause of action to claim balance quantity was given by the judgment and decree of the money suit itself.
At best.
At best. He has submitted that it was for the plaintiff to approach the appropriate authority for release of the balance quantity, but no such step was taken, and after the disposal of the criminal case in the year 2015 and after expiry of how many years?
23 years from 1990.
23 years from disposal of the money suit, the plaintiff has tried to revive its dead claim by referring to the acquittal judgment and claiming the remaining quantity at the same rate which was fixed way back in the year 1980. The learned counsel has also submitted that as per Exhibit 2, Exhibit 2 and
Exhibit, particularly instruction of tender terms and conditions.
as per the terms and conditions of the
Tender slash sale.
tenders, which is instruction to tenders within bracket terms and conditions of tender sale.
Clause 12, 10 and 12A.
Clause 10 reveals that the purchaser has to lift the material in installment, but the payment has to be made at one go.
Yes. And that too within 10 working days commencing from the date of tender.
And the payment was to be made within 10 working days commencing from the date of tender. We have submitted that admittedly the plaintiff has not deposited the entire value of the material, and even after the judgment passed in the money suit, the entire value of the remaining material was not deposited. He has further submitted that
My contract was concluded with them only with respect of 16,62,000.
he has also submitted that the contract was enforceable only in connection with the amount which was deposited by the appellant and nothing more. He has also submitted that the very fact that the defendants were undertaking sale to third parties itself indicated that there was the learned counsel has also referred to the list of materials, clause 33, and has submitted that the specific quantity of material with description and location was given, and therefore there can be no doubt that the material was available and earmarked for the purpose of the contract.
They themselves in plaint says that in 1982 I don't supply them, but I sold to another person's by
Yes, he has submitted that the plaintiff have themselves said that the material was being supplied to third parties.
para 19 of plaint.
Was being supplied to third parties, but in the suit and the claim of security deposit, refund of security deposit was denied, but the plaintiff never challenged that judgment. But either parties never challenged that judgment. The learned counsel has referred to clause 12 with that A of the terms and conditions of contract of tender to submit that in the event of failure to complete payment of sale value of the material by the purchaser within stipulated period, the sale of such material will be cancelled, security deposit will be forfeited, and the material shall be resold or otherwise disposed of without any notice to the purchaser, and any loss on resale shall be recovered from the purchaser.
And therefore, I was not bound either to give notice of cancellation of contract, nor for forfeiture of security deposit, nor for resale.
The learned counsel has submitted that in view of clause 12 within bracket A, no further steps was required to be done by the defendants. The very act of selling the goods to third party itself indicated that there was disruption in the contractual relationship between the
There was
parties.
rescission of contract.
There was rescission of contract.
Why?
The learned counsel has submitted that the cause of action at best arose within 3 years from the date of the judgment in the money suit, which expired sometimes in the year 1995, and the suit has been rightly held to be barred, hopelessly barred by limitation, which was filed only in the year 2015, 2016 perhaps, 2016. 2016.
2016.
The Learned Counsel has submitted that the letter issued by the plaintiff in the year 2015 after disposal of the criminal case has no bearing, as the money suit never indicated that the plaintiff will be entitled to supply after the disposal of the criminal case. That's it. और कुछ बोलना है?
Yes, and initially in my written notes of argument, page 2, I have stated that for suit for specific performance of contract, the plaintiff has to discharge owners in terms of section 16C. Page 2, ladies.
Page 2.
Page 2 top. The plaintiff has to discharge owners in terms of 16C of specific relief act with 3 ingredients. First, there is a valid and effective contract. Second, the plaintiff has performed his part of contractual obligation and is all along ready and willing. And third, the defendant has failed to discharge. And then I have elaborated.
Okay. The Learned Counsel for the respondent has also referred to section 16 with bracket C of the Specific Relief Act 1963 to submit that 3 basic ingredients are required to be satisfied to seek specific performance of contract. They are: number 1, there is a valid and effective contract. Number 2, the plaintiff has performed his part of contractual obligation and is all along ready and willing. And number 3, the defendant has failed to discharge its contractual obligation. The Learned Counsel has referred to the materials on record and has submitted as under. इसको quote कर लेते हैं?
Yes.
यहाँ से
Yes.
इनके written submission से ना quote करना है internal page 2 से. This is on behalf of respondent.
Just before Ray B, I have framed the issue whether suit of specific performance is maintainable. So my entire answer to question 1 is with respect of specific performance. 3
तो
points.
ये हो गया this one, right?
Then third is that whether the contract between the parties are impliedly cancelled in terms of X, 5A, 5B, 10. And then
Thus, in view of it can be safely construed that the contract between is to impliedly cancelled.
yes, that is with respect of my cancellation. And third is that whether I am entitled to refund the security deposit.
Okay.
That is the third.
ठीक.
Only few lines I left today what I have submitted before revision. 62 of the evidence contract act.
Where is your pen drive?
Pen drive.
आप भी दे देंगे हमको पेन ड्राइव में दे देंगे. आपका कोई पॉइंट तो छोड़ो
I can
नहीं
mail
आएंगे.
it. Can I mail it?
Only the answer to
Can I mail it?
मेल.
Soft copy I will
अच्छा
forward.
मेल कर.
Soft copy I will give it to the
हाँ
court
सॉफ्ट
master.
कॉपी. Yes.
only on clause 10 and clause 12. All the incidents. My first submission is clause.
एक सेकेंड उनका कंप्लीट कर लेते हैं. I let you. ठीक है. The Learned Counsel has further submit. वो तो हो गया 12A आपका कंप्लीट हो गया.
12 complete हो गया.
That should be sufficient.
Yes, and I have said so that since there is no contract and by implied cancellation it was done
That's
way back, therefore I am not entitled, it is barred by limitation in this judgment.
Yes. The
Once
Learned
limitation-
Counsel has also submitted that once the suit is held to be barred by limitation, there is no question of entering into the merits of the matter.
Parents 22-23 will serve that.
He has referred to the judgment passed by Honorable Supreme Court reported in bracket 2008 bracket close 12 SCC 577 paragraph 17 para 24 है
17, 18, 19,
17 18 19 20
22, 23.
22 and 23 with respect to examination of power of attorney, the learned counsel has relied upon paragraph 12 of the judgment reported in 2024 SCC Online SC 981. Rajesh Kumar versus Anand Kumar and others, paragraph 12, right? That's all?
Rest? Written notes of argument.
Sorry? हाँ, written notes
Something
of argument
written
में
notes.
आपको क्या
Only clause 10.
रिस्पॉन्स में बोलिए आपका कुछ छूटा है
नहीं, खाली response नहीं, clause 10 होता है.
क्लॉज
10 in clause 12, which my learned
of the
of the tender matters.
okay.
Exhibit 2 matters. Which clause 2 my learned friend is misinterpreting. The what clause 10 provides matters is
that I have recorded. I will just repeat it. आपने
Not
बताया
finding
था ना
of-
कि इंस्टॉलमेंट जब नोटिफाई एग्जिबिट 8
matters.
right?
So that it has to be there. The payment is only in full in terms of the installment, not of the entire total contracted quantity.
That's
And section 12, which my learned friend is relying on for implied cancellation, that event of implied cancellation was even there in the 82C.
that's
But even then, the 92 judgment said that the contract is still valid,
That's
and they never challenged.
That's right. In response, the learned counsel for the appellant has submitted that clause 10 of the exhibit 1, exhibit
Only exhibit two.
exhibit 2 is wrongly interpreted by the counsel for the respondent. He submits that the payment was to be made to the extent of availability and readiness on the part of the defendants to supply, and the parties had understood it in that manner. Consequently, Exhibit 8 was issued asking the plaintiff to make payment with respect to the quantity which was ready for supply. With respect to clause 12 within bracket A, the learned counsel has submitted that the fact that third parties were being supplied was already on record in the earlier money suit, but in spite of that, the learned court had decreed the suit and had held that the contract was still valid and had directed and had permitted the plaintiff to approach the defendants for the supply of the balance quantity. And therefore, the said judgment having not been challenged, it is not open to the defendants to say that by their conduct of selling the property to third party, the contract stood terminated. The learned counsel submits that under such circumstances, the plaintiff is entitled to refund of the security deposit, as the defendants have not foreclosed the contract so far. है ना?
And
Right?
had retained the security deposit all the while.
And have
Consciously retained.
consciously retained the security deposit throughout. Just tell me one thing I want to know from you. Is there any pleading in your plaint or amended plaint as to what you did during the period 1992 to 2015? Show me one statement to support your evidence exhibit 10.
Paragraph 25 of plaint is about 1992 order, and then 26 is straight away
No,
2015.
that उनको बताने दीजिए ना, उनसे पूछना है। आप क्यों इसको-
Para 25, it says that the security deposit was retained by the defendant till date and is still lying with the defendant. The facts that the contract has not been terminated are there, but the fact that after 92 minutes and prior to disposal of that criminal case, we had approached them, that is not. But the fact that the contract is valid and subsisting and they are retaining the securities for it, that is not. But after 92 and prior to disposal of the criminal case, readings are not there.
The points for determination, आपने इनका देखा है? इन्होंने जो फ्रेम किया points for determination, चेक कर लीजिए इसमें से कुछ छूट रहा है तो.
Broadly, these are the point of determination, except they have been contending that it has been barred by DT. The last C, they say that after influx of inordinate limitation, that act is disputed.
I will frame it slightly differently. One में तो कोई दिक्कत नहीं है. 16C is a basic ingredient of specificity fact.
I would say that this point was never raised before even the court below this. This is absolutely a new point which is coming and without any pleading, without any evidence.
B we will not able.
That is
Absolutely a new
point. Limitation. One day I have framed and I have framed.
B
that-
will not.
But the question of limitation has to be framed. That has to be answered.
हाँ, इसको ऐसे करेंगे. Whether the suit is barred by limitation.
Yes.
Simple question.
Yes. Because that is the fundamental question.
Whether the suit is barred by limitation is one question.
Fund of security deposit of rupees 50,000 along with interest, that's when can stop at.
Bas, the third will be whether he is otherwise also entitled for refund of security deposit of rupees 50,000.
My solution once limitation is decided.
I have no.
Yes. And only one line. As they relied Article 54 of limitation. That line.
Entitled to. क्या बोल रहे हैं? Whether this suit was at all maintainable. This is also important. Suit could have continued before the court. Commercial court वाला, right? जरा frustration किसमें होता है, कौन सी section?
That's that.
Frustration of contract. 50,000 तो इनका बनता है. I'm just trying to find out कि कहाँ से इनको दे सकते.
Impossible to
Frustration. If you hold that there is frustration of contract, still the plaintiff would be entitled.
frustration of contract with. That is the relevant. If the frustration
कोई
of
frustration कौन सा section है?
yes.
The exact event of frustration has to be pleaded, evidence has to be lead.
आप ही के लिए सोच रहे हैं ये 50,000 रुपए तो आपके ऊपर जबरदस्ती हो गई.
Section 56 relation, the contract become later impossible.
Section 46.
Agreement to do an impossible act, it is categorized into part. Contract to do an act. 56. Agreement to do an impossible act. 46 is time is essence if not prescribed within reasonable time. Section 46. 56 says agreement to do impossible act. It has two parts. Contract to do an act afterwards becoming impossible or unlawful. A contract to do an act which after a contract is made become impossible or by reason of some event which the promisor could not prevent, unlawful becomes void when the act becomes impossible or unlawful. Frustration is section 56. 56. For frustration, compensation can be granted to the applicant. My reading will be that at the time of entering contract, I must know that either it is not non-performable or I know it is a void agreement. Still I enter, which is not clear.
Article 54.
Article 54 of Limitation Act, they read it in a different way. It's 3 years, the date fixed for the performance. The date fixed for the performance, or if no such date is fixed, when the plaintiff has noticed that performance is reduced. Here notice doesn't mean written notice. Notice means information that I refused my performance. So I refused my performance either in 82 when I sold it to someone else, or after 92 when you have sent me at best their case. 92 after judgment you sent me one letter but I said tight over. So the 3 years is either from there or this.
Reciprocal promises बताइए. Reciprocal promises. Reciprocal promises.
The contract.
You see, by virtue of this judgment, there was an obligation on their part to come to you, and there was a counter obligation on your part to supply.
They approved.
They never approved.
My case is they never approved.
They never approved,
based.
and they have practically proved that they have not been able to prove that they approved.
My
That
argument
is there.
of twofold. First argument, they never approved. And second, at best their case is accepted that they approved in 93. Then for how much period? For 3 years. That is the window period for them to come to the court. Because my inaction will not give rise to a cause of action for next 25 years. and I never acknowledge the responsibility which can give continuation to the cause of action. Had it be a case 93 में आता और हम एक चिट्ठी लिखते कि हम कंसिडर करेंगे, then 3 साल के लिए इनका रिवाइव था, then 95 में अगेन कहते कि अभी आपका एक्विटल नहीं हुआ उसके बाद कंसिडर करेंगे, then again 3 years. That is not the case. That it keep reviving and there is continuation of cause of action. Inaction is committed.
He could have approached you. You could have refused or accepted.
Yes.
Upon this refusal or acceptance, his refund of this security deposit would have depended.
Yes.
So he never approached you. So there was no cause to even get the security deposit. Had he approached at relevant point of time, he would have claimed the security
Yes.
deposit at that point.
And therefore, I referred section 46, which says that if no time was ever fixed, then it has to be time for performance of promise. Section 46. Time for performance of promise when no application is to be made and no time is specified. That is the best.
Section 46 of
Indian Contract Act. If time is not fixed, then
yes.
where by the contract a promisor is to perform his promise without application by the promisee and no time for performance is specified, the engagement must be performed within a reasonable time. Then explanation, the question, what is a reasonable time, is in each particular case a question of fact. So the court has to consider that if the contract doesn't fix a particular time to perform, then what is a reasonable time under which a party can say that he is still legitimately expecting that I will perform?
So he was he was supposed to
Again,
approach you within a reasonable time.
yes, 3 years. If not that, okay, then 4 years, 5 years, 6 years. That at best court can say that yes, it appears to be. But 25 years can't be a reasonable time to ask someone to perform his part of obligation. It is not reasonable because reasonable time, this concept will vary from case to case. Because reasonable time they can say not 3, 5 years.
आप लोग का सब चीज दिखा दिए हैं.
Yes.
I'm pronouncing the judgment. I
Yes.
use the chamber and
Yes.
dictate the remaining portion. Maybe today or tomorrow, right? This appeal is dismissed. I really can't help it.
But my only submission is Article 15 is the relevant section for limitation. Article 15 says there has to be a notice of refusal. No, there was no notice of refusal.
We take care of everything. ये आपका रख लें हिंदी वाला. कल एक केस में ऐसे प्रोनाउंस किया था ना परसों, कल की परसों वो जो कर रहे थे लैंड एक्विजिशन वाला, कल किसने डिक्टेशन हु वाज दैट लैंड एक्विजिशन वाला जिसमें मिस्टर मुखोपाध्याय अपीयर कर रहे थे रिस्पॉन्डेंट की तरफ से और अपीलांट की तरफ से थे सौरभ जी का ड्यूटी का आस्क हिम टू कंप्लीट. उनको बोलिएगा जितना डिक्टेशन दिए थे उसको कंप्लीट करने है ना. चलिए नेक्स्ट
लास्ट लाइन एक बार काइंडली देख लें.
For judgment action 3 from the primitive list first appeal 210 of 1993.
This appeal is dismissed. हम लोग का पास ओवर है फर्स्ट हाफ में.
Password case item 1 second appeal 236 or 2003.
In this case,
You are the plaintiff.
plaintiff appellant and appellant.
You have read the substantial question of law.
Substantial question of law, two substantial questions of law in the claim, my lord. First substantial question is, my lord, whether in view of the receipt in Exhibit B, the court below are in law in holding that Musmar Papu Hansda was not governed by Santhal custom and had ceased to be a scheduled tribe. And second question of law, whether the provision of Hindu
दोनों related है.
दोनों related है.
If she is a scheduled tribe, then there is no question of applicability of this Hindu Adoption and Maintenance Act. And if she is not a scheduled tribe, then only Hindu Adoption and Maintenance Act would apply. And so far as first question of law is concerned, it is based on the recital of Exhibit B.
Exhibit B,
What is
Exhibit B
सिर्फ Exhibit B के बारे में. It is only in connection with Exhibit B. Recital in Exhibit B.
Exhibit B solely
Alaihi sir.
adoption
Exhibit B
deed
adoption registered adoption deed.
adoption deed.
और ये एग्जिबिट बी पढ़ी. इसमें कौन सा ऐसा चीज़ है जो उनको ट्राइबल डिक्लेयर करते हैं?
Lordship, God and all matter is suffering from fever mind. Mr. Rajiv Sharma.
अच्छा ठीक है, हम आपको टाइम देंगे ना, आप बताइए ना, इसमें पढ़े होंगे. अरे वो छुट्टी पर है तो आप कुछ करेंगे ना, हम आपको टाइम देंगे. देखिए इतना पुराना केस लिस्ट में लगा है, ऐसे नहीं हम डिसाइड करेंगे. जैसे रेस्पोंडेंट नहीं अपीयर हो रहा, अभी तुरंत एक एमाइकस अपॉइंट करेंगे. ठीक है, हमें असिस्टेंस चाहिए, किसी को एमाइकस अपॉइंट करेंगे, somebody will assist. आप हैं क्या रेस्पोंडेंट? आप तो उधर कोना में क्यों बैठे, इधर आइए. इसको थोड़ा पढ़ लेते हैं, इसमें देखते हैं ऐसा क्या चीज़ है इसमें कि इसको लेके क्वेश्चन ऑफ लॉ बना. सिर्फ एग्जिबिट बी के एप्रिसिएशन को लेके क्वेश्चन ऑफ लॉ बना है ना. मिला आपको एग्जिबिट बी? क्या नाम है? पिंकू हंसदा. मौसमात पाकू हंसदा.
Papu Hansda, proceed. I read exhibit B, madam. नाम पुष्पुत्र मुस्मात तमकु हंसदा पति स्वर्गीय जमला जटला पिदु जाति पति का नाम जाति का नाम संथाल जाति संथाल पैसा चारू साकिन केटाती शंकर हरिपुर थाना जमुंडी जिला दुमका उम्र करीब 55 वर्ष। नाम बेटा श्री बृहस्पति राय, पिता वतन राय, वो श्रीमती दंपति सरस्वती देवी, पति पति नारायण, ऐसा नौकरी से चारू साथी तिवारी सर्कल हरियाणा थाना जमुंडी डिवीजन वो जिला दुमका भारतीय। नाम पुष्पुत्र महेंद्र राय, जन्मदाता पिता श्री बृहस्पति राय, जाति घटवाल, पेशा नौकरी एवं चारू साकी हरिपुर थाना जमुंडी एवं डिवीजन वो जिला दुमका।
है ही नहीं रहा। आप इसको टाइप कराइए, एग्जिबिट बी को टाइप करें। कब रखने में
आफ्टर 1
आज कौन सा बात? नेक्स्ट वेडनेसडे,
नोट्स
ठीक है। With the consent of the learned counsel for the parties, fourth space for final hearing on next Wednesday. However, it will come under the same hearing to be taken up at 10:30. First case, कोई रखने हैं क्या 10:30? नहीं, कभी नीचे रख, नहीं रहना, ऊपर है। 10:30, 10:30 बजे आइए। चलिए, कुछ ऑर्डर्स के केसेस हैं हमारे सब्मिट की लिस्ट में। उसको टाइप करा लेंगे,
फर्स्ट अप्रैल 157
हमको भी प्रोवाइड करेंगे और उनको भी। Which targeted case?
First targeted case of Delhi.
अच्छा,
Name
एक just
only a date may be fixed. Any date where date is not possible. So only I have difficulty on Wednesday and Thursday next week. Whatever else date you choose.
देखिए, अभी तो वो केस आप देख रहे हैं, पुराने केसेस में टाइम लगेगा। एक दो ही सेकंड अपील हो
ठीक
पाएगा।
है, जैसा जो
केस लिस्ट में है,
हाँ।
जब टेकअप होगा, आपको जरूरत होगी, हम आपको जरूर टाइम देंगे।
हाँ, नहीं
लेकिन
ऐसा नहीं
प्लीज बी
होगी।
प्रेजेंट,
हाँ,
ये इम्पोर्टेंट है, ये जानने के लिए कि लिटिगेंट जीवित है कि नहीं है, क्या सिचुएशन है, पता चले कि ऐसे डीएफडी तो हम एक भी केस नहीं करेंगे, कोई भी केस हम डीएफडी नहीं करने, हमको करना ही नहीं है। कोई भी आप लोग बोलेंगे तो टाइम देने के लिए थोड़ी कोई मनाही है, थोड़ा सुन के टाइम देंगे,
नहीं ये तो 3 दिन
ऑर्डर पढ़
पहले
के
से आ
टाइम
जाए,
देंगे।
3 दिन पहले से आ जाए तो ऐसी क्या
नहीं, ठीक है, ऐसी कोई बात नहीं है, आप टाइम मांगेंगे तो आपको जरूर देंगे। लेकिन कोई केस अगर पकड़ाता है और एक बार हम लोग उसको इम्प्यून ऑर्डर
ठीक,
पढ़
ठीक।
लेते हैं, फिर अगला डेट हम टाइम नहीं
ठीक
देते,
ठीक
बस यही है और कुछ
ठीक।
नहीं। ठीक है, तो कौन सा डेट आप लोग चाहिए?
जो फर्स्ट जो लगा हुआ था
क्या मैटर है सेकेंड अपील का, क्या मैटर है?
ये शिया लॉ ऑफ इनहेरिटेंस,
शिया लॉ ऑफ इनहेरिटेंस जो उस दिन एडजर्न हुआ था, उसका तो नोट्स ही बनाइए आप लोग सबसे
तो
पहले। आप नोट्स बनाइए, ऐसे नहीं हो पाएगा।
रेडी है प्रैक्टिकल,
हम आप रेडी है, हम लोग
नहीं,
का नोट्स पढ़े नहीं समझ।
हम लोग का नोट भी रेडी।
अच्छा, नोट भी रेडी है, कब करें बोलिए? कब करना
लोग
चाहते
तो बोल रहे थे यार।
एक तो चूंकि दो केस है, आई मस्ट डिस्क्लोज एवरीथिंग। आज का ही लिस्ट में फर्स्ट और सिक्स दोनों पार्टी सब एक है। फर्स्ट वाला
कौन सा पार्ट है?
पार्ट खत्म हो गया।
6 पार्टहर्ड है, लेकिन वो पार्टहर्ड और पार्टहर्ड स्टैंड रिलीज करके लिखा हुआ है।
पार्टहर्ड लिखा हुआ है, पार्टहर्ड जैसा कोर्ट का मर्जी है।
नहीं
नहीं सर, वो
ऑल
list में
पार्टहर्ड हैज बीन रिलीज्ड।
पार्टहर्ड लिखा हुआ है, आप पढ़े नहीं हैं।
लिस्ट में लिखा हुआ है पार्टहर्ड हैज बीन रिलीज्ड।
पार्टहर्ड ऑर्डर में लिखा हुआ, हमारा काम है आपको जानकारी।
नहीं वो
नहीं,
ठीक
हम लोग को
लेकिन-
जितने भी हमारे भी बहुत सारे मैटर्स जो पार्टहर्ड दूसरे कोर्ट में गए हैं सब वहाँ से रिलीज हो गया।
पार्टहर्ड लिखा हुआ है उसमें, आप देखिए लास्ट लाइन ऑफ द ऑर्डर
दिखाई जरा
पढ़े हुए
कहाँ
इसलिए बोल रहे हैं।
नहीं वो नहीं है। नोटिस में आया है कि जितना पार्टहर्ड है सब कॉन्स्टिट्यूशन नहीं है।
अच्छा अच्छा अच्छा, वो
देयर इज अ जनरल नोटिस टू द पब्लिक।
हम नहीं देखे।
हाँ वही
वही है ही।
कोई दिक्कत नहीं।
कौन सा सीरियल नंबर 1 and 6
1 and 6
टू बी टेकन अप टुगेदर।
नहीं अब एक एक करके किया जाए। हम लोग
1
दोनों
and
का ही
6 is between the same parties.
हाँ वन आफ्टर द अनदर।
Is between the same parties.
और एप्लेट हम लोग
हाँ सीरियल 1 में पहले हम लोग
Is it out of the same impugned judgment?
नहीं दोनों अलग अलग तो
दोनों अलग
पूरा
जजमेंट है, दोनों का प्रॉपर्टी अलग है।
दोनों properties
Property
अलग-
अलग है इसलिए अलग अलग जजमेंट।
और दोनों अलग अलग सूट भी
अच्छा,
अलग
बाद में
इश्यूज भी सेम है कि अलग?
नहीं प्लेंटिफ भी अलग
नहीं,
है,
अलग है।
डिफेंडेंट भी अलग है, दोनों
अलग।
जो इसमें प्लेंटिफ है फर्स्ट केस में, इसमें यहाँ डिफेंडेंट है फर्स्ट केस में, दूसरे केस में प्लेंटिफ है, इसमें दूसरे केस में डिफेंडेंट है।
फैमिली एक ही फैमिली का
कब करना चाहते हैं बताइए? 1 and 6 एक के बाद एक करेंगे, जिस दिन बोले तो उस दिन करेंगे।
हमको नहीं बोलना, आपको बोलिए, ताकि बहुत जगह ट्रेवल कर चुका है।
नहीं ठीक है हम
अब ट्रैवल बंद,
अब नहीं हो,
अब स्टेशन पे रुक गया है, अब उतर के ही जाएगा। अब नो ट्रैवलिंग हो
बहुत
गया,
ट्रेवल हो चुका है।
कुछ नहीं होगा सर।
स्टार्टिंग फ्रॉम द ईयर 2005 itself. Here
आप
we-
चिंता मत करिए। आई एम द सिंक
हम
ऑफ ऑल
जानते हैं।
ट्रैवलर्स।
Now it should stop. बढ़िया से बोल
या तो 11th 12th होगा, नहीं तो देन 18th वाला वीक जो है उसमें जो भी कन्वीनियंट।
ठीक है, 18 के बाद यही बात ही रहेगी।
With the consent of the learned counsel for the parties, item number 1 and 6 का, ठीक है? Both these matters are directed to be posted on 19th August.
21st,
19th.
19th.
नहीं अलग अलग होगा लेकिन रहेगा उसमें दोनों का 19th। कुछ तो हम लोग ऐसा करें नहीं, कुछ तो डिसाइड करें ढंग का। मतलब these challenging cases are really I like it।
हाँ है इसमें सेकंड
और
वाला
नया
तो
चीज भी सीखने मिलता है ना, ऐसे
इकबाल
शिया
का-
लॉ का कहाँ पढ़ते हैं?
ऑनरेबल जस्टिस इकबाल साहब के यहाँ जब इम्प्रेस हुआ था, उनका कहना था लेयर ऑफ द रेयरेस्ट या लॉ का
बोले थे कि हम मोहम्मद अल्लाह को अभी तक नहीं
नहीं
समझते,
समझते।
यही बोले थे।
चलिए ठीक है। अब ये वाला ये ऑर्डर्स में FA 157 कहाँ है मिस्टर मिथुन कुमार? सुबह से थे यहीं पर, क्या है कि रेस्पोंडेंट कहाँ है? बुलाइए बुलाइए इस ऑर्डर को, इसको खत्म करना है। टिकट नंबर 1 अभी तक रिमूव नहीं किए हैं। ये इनका ना सर्टिफाइड कॉपी नहीं फाइल किए हैं, तो हम इनको
हम
टाइम
इन्फॉर्म कर देते हैं उनको।
उनको खबर करें, ठीक है? लीजिए। FA number 157 of 2018. As per the office note, defect number 1 has not been removed. Time till 27th August is granted to the appellant. Till 25th August is granted to the appellant to remove the defect number 1 or to file appropriate petition in this connection. Post on 27th in the supplementary cost. वो लोग पिटीशन फाइल करते हैं सर्टिफाइड कॉपी के
नहीं बोल भी रहते हैं हमको उसकी सर्टिफाइड कॉपी फाइल करना है, उसके बाद अभी अंदर है
सर्टिफाइड कॉपी है उनके पास?
नहीं तो नहीं बताया, बोले हमको फाइल करना सर्टिफाइड कॉपी, हम टाइम नहीं देते।
तो ठीक है, टू रिमूव द सर्वाइविंग डिफेक्ट्स खाली बोलिएगा, आइए फाइल करने का कहानी मत लिखिए। 25 तारीख तक, ठीक है? प्रेम्पटरी ऑर्डर नहीं दिए
जी,
फर्स्ट अपील को ऐसे डिसमिस नहीं करना चाहिए।
Item 6, first appeal 1/4 of 2018.
इसमें भी सेम ऑर्डर कर दीजिए। डिफेक्ट नंबर 1 ने इसमें सारे डिफेक्ट्स के लिए सर्वाइविंग डिफेक्ट्स। आप हैं रिस्पॉन्डेंट, कवर्ड केस है, अननेसेसरी डिफेक्ट तो पड़ा हुआ है।
Orders. Item 7, second appeal 39 of 2005.
ये क्या जिसके लिए आया है?
पार्टी बनाने के लिए एक एप्लीकेशन दी है ऑन द ग्राउंड दैट दे आर द subsequent purchaser. Earlier lot the same petition was filed which was rejected by this honorable. This fact has been suppressed by the respondents lots.
कौन है? आप फाइल
Mr. Rajesh.
I was appearing for the Malad earlier.
39. आप है ना?
Now I am appearing for other respondents.
ये subsequent purchaser.
Subsequent purchaser.
आप सब्सिक्वेंट परचेजर। आपका पिटीशन पहले रिजेक्ट हुआ। Your petition has been rejected earlier.
File the counter letter annexing the copy of this honorable annexure 1 lot.
ये डीएपी हो गया।
डीएपी हो गया, उस पर एक और ऑर्डर देखा जाए कि टाइटल अपील में भी फाइल किए तो रिजेक्ट हुआ है, उसके उस चीज को भी सप्रेस किए हैं। दिस इज द ऑर्डर ऑफ टाइटल अपील लॉर्ड्स। इसमें उसमें मेरे पास कॉपी नहीं था, बाद में आया।
देखिए उनको कुछ फाइल करने तो बोल नहीं रहे,
नहीं
ठीक है? He may just assist the court.
लॉर्ड्स
Only for that purpose. After all, he is a subsequent purchaser.
लॉर्ड्स द
बेचने वाला तो भाग गया।
the same petition has already been rejected before the learned appellate court lords, which was rejected lords. May kindly see, and these facts have been suppressed by the intervener lords, the subsequent purchaser lords.
Partition suit है,
हाँ, partition suit.
pendentillite and not necessary party.
Yes, already rejected.
We will permit him only to assist. कुछ नहीं, इसके beyond कुछ नहीं। Only to assist the court. What is the big deal about it?
According to section 52 lords, any judgment in decree pass which is binding upon all the parties.
Certainly it is
Therefore,
binding.
lords, the subsequent purchaser is not a necessary party lords.
That's right. But you see, when there is a subsequent purchaser, then under such circumstances, if he assists the court on the basis of materials on record, what's the big deal about it? कुछ evidence थोड़ी देंगे ये।
But the lords,
The problem is, बेच के भाग जाता है।
नहीं है ना ये है, ये फाइट कर रहे हैं।
original landlord we are.
हाँ ये फाइट कर रहे हैं, बेच के भागे नहीं यहाँ फाइट कर रहे हैं यहाँ पर। टाइटल अपील में भी रिजेक्ट हो चुका है, फिर एक बार डीएफडी हुआ ऑनरेबल हाई कोर्ट में, उसके बाद फिर फाइल किए हैं। आपको ये जितनी भी बातें हैं कुछ लिखे भी नहीं है।
टाइटल अपील डिसमिस हुआ है।
हाँ, आपका your intervention has been rejected at the title appeal.
Against which no appeal was filed, no CMP was filed before the honorable court.
अब किनकी तरफ से petition मोहम्मद यूनुस अंसारी? Who has filed this petition? मोहम्मद यूनुस अंसारी.
जी, मोहम्मद यूनुस अंसारी फाइल की।
कई लोग बहुत फाइल। देखिए आइए नंबर 1806 of 2022. This petition has been filed seeking addition of the applicants in this appeal. It has been submitted by the applicant, by the learned counsel for the applicant, that the applicant is the subsequent purchaser. And has purchased the property during the pendency of the partition suit number 6 of 1981. In relation to half share of the property. Half share खरीदे हैं, by registered sale deed dated. बताइए deed.
नेक्चर 1 लगाए हैं, आइए मैं नेक्चर 1 लगाऊं।
By registered sale deed. The learned counsel for the petitioner has opposed the prayer and has submitted that similar petition was dismissed by this court by order dated 6/12/2018, and as nobody had turned up to press the petition, he has also referred to order dated 25/5/2004 passed by learned First Appellate Court, wherein the similar petition was rejected by observing that the subsequent purchaser pendentillite are not necessary party in the appeal, and they can derive their share as per the decision of the court for their vendor.
And against the order passed by the learned district judge, no appeal or revision or CMP was filed.
The learned counsel has submitted that the applicant has purchased the property during the pendency of the suit, and his right, title, interest, etc. will be governed by the principles of res pendens. He submits that the application may not be entertained. The learned counsel for the
One more submission.
respondent,
Rest of
the vendor, is present. He submits that he shall be contesting the suit, contesting the second appeal. Considering the aforesaid submissions and the fact that the petition seeking intervention was rejected by the First Appellate Court also, and was also rejected by this court earlier on 6/12/2018, this court is not inclined to allow this intervention application seeking addition of party. Accordingly, this petition is hereby dismissed. इनके साथ रख के करिए, ठीक है? ये order dated 25/5/2024 produced by the learned counsel for Tapina district number. अब ये क्या चीज़ है? कब का मैटर है?
2005 का है।
अब 2005 का मैटर में क्या चल रहा है?
तैयार है हियरिंग।
Substantial question of law बना है?
बना है।
जी बना हुआ।
कहाँ बना है? Is it Muslim law?
Yes, ma'am. By an order dated 10/12/2021.
10/12/21.
20. At order number 60.
15 साल बाद.
At order number 60.
तो पूरा दिन का कैसे? Full day. अभी कुछ मैटर्स फिक्स किए हैं. ये वो 20 years old वाले में नहीं आता.
नहीं आ रहा
टारगेटेड केस में नहीं आ रहा है.
है।
लेकिन अभी तुरंत इसको नहीं करना.
ठीक।
ठीक है. मुस्लिम लोग की कुछ और भी मैटर्स फिक्स किया अभी आप देखिए.
जी
इसको थोड़ा दिन बाद करें. Post this case on under appropriate heading on 16th September.